Welcome to the Political Institutions and Political Economy Pipe Workshop at the Bedrosian Center here in the Price School at the University of Southern California. I'm Jeff Jenkins, the director of the Bedrosian Center and the Pipe Collaborative. And our workshop speaker today is Professor Maya Sen. Maya is a political scientist and professor of public policy at the Harvard Kennedy School. She writes on issues involving the political economy of U.S. race relations, law and politics, and statistical methods. Her research has been published in journals such as the American Political Science Review, the American Journal of Political Science, and the Journal of Politics, and has been covered by the New York Times, the Washington Post, National Public Radio, and other outlets. She's testified before Congress and presidential commissions. Maya's newest book, The Judicial Tug-of-War, How Lawyers, Politicians, and Ideological Incentives Shape the American Judiciary, with Anna Bonica, is now available from Cambridge University Press. Her first book, Deep Roots, How Slavery Still Shapes Southern Politics, is available from Princeton University Press and won the 2019 William H. Riker Book Award for the best book published in political economy. Maya's presentation today is entitled How Judges' Professional Experience Impacts Case Outcomes, an examination of public defenders and criminal sentencing. Following the presentation, we'll have a formal discussant, John Kastelic, who's Associate Professor of Politics at Princeton University, to provide some comments. During Maya's talk, if you have any questions, please type them in the chat or Q&A box. I'll be monitoring questions as the talk goes on. And without further ado, I give you Professor Maya Sen.
So hi, everyone. Thank you so much for having me, and especially to John, who's going to be providing discussing comments. I'll thank him in advance. Since I'm not sure, I'm going to want to thank him afterwards. I'll go ahead and share my screen. I'm just kidding, John. Jeff read the title of the paper out loud. I just want to flag that this is joint work with Allison Harris, who is an assistant professor at Yale, who studies a lot of topics having to do with criminal justice, race, and the legal system. So this is very much a collaborative project. And it's also very new. This is actually the first time that either one of us is presenting it. So it's really ripe for feedback. We've actually only shown this to a handful of people. So I'm very excited to hear your thoughts on it. So just to give you a sense of what motivated this research project, by now, almost everyone who follows politics closely knows who this is. This is Ketanji Brown Jackson, who is President Biden's nominee to replace Stephen Breyer on the Supreme Court. And Judge Jackson herself has public defender experience. And that's come up as something that Democrats have coalesced around being particularly important in terms of her background, and Republicans have seized upon as potentially being a source of criticism. So how could Judge Jackson's background as a public defender potentially impact her decision-making on the Supreme Court? Well, she's actually talked quite a bit about it and written about it. This is just a quote that I pulled that kind of illustrates the way that she speaks about it. So here she says, defense lawyers perform a service and our system is exemplary throughout the world precisely because we ensure that people who are accused of crimes are treated fairly. This is actually very consistent with other things that she said, that she sort of believes that people are entitled to representation, and representation of both sides of a criminal case is very important for the system to function. She very much focuses on the right to counsel as being sort of what her public defender experience has shown her is very important. So this is consistent with the way that she's explained how her public defender experience illuminates her decision-making. Now, on the other side, we have, this is just an example from Chuck Grassley, but this is pretty consistent with what Republicans have said. He says here, we need to carefully scrutinize these federal defender nominees because the left seems to think they'll rule in a certain way. And that certain way, sort of the implication is that they're going to be soft on crime, that they're going to let vicious criminals out of jail. There's this sentiment going around that it's particularly the case when it comes to like child sex abuse defenders, which I don't really understand, but there's sort of this narrative that this public defender experience translates to being soft on crime. And that is what Republicans are sort of seizing on as being kind of the important facet of this public defender experience. We actually started studying this topic before President Biden named Judge Jackson. So we're kind of looking at more like, well, what is it that about public defenders that might be particularly important? And the reason why we got interested in this was not because of Judge Jackson, but it's because Joe Biden has actually up the number of public defenders as judges by quite a bit. So 1/3 of his appointments have had this public defender experience. And that to us marks a new strategy in how politicians have approached judicial appointments. So in years past, presidents and political elites have actively used the background of judges, but they've done so primarily to curry favor with specific constituencies. So, a really prominent example here is Ronald Reagan. He actually made a campaign promise that he was going to be the president to name the first woman Supreme Court justice, and then he did so with Sandra Day O'Connor. And there's sort of different examples of that. And Judge Jackson's actually consistent with that because Biden made the promise to nominate the first Black woman, right? So that's usually the way in which judicial backgrounds have played a role in the nominations process. It's to curry favor with specific politically important groups. This is actually different. This is a case where maybe Biden isn't phrasing it this way, but certainly advocates are. This is using the identity, and in this case, it's specifically the professional background of a judge to actually further a certain kind of policy agenda, right? So the sentiment among certain advocates is that you can use public defenders in a way that would advance certain policy interests. So here's an example from, some of you might know Chris. Chris Kang is the chief counsel of a group called Demand Justice, which has been very active in identifying potential judicial candidates. He worked for the Obama administration. Now he's transitioned into more of this advocacy role. But he said, this is a quote that's pretty typical of the things that he says, "Our judiciary has been dominated by former corporate lawyers and prosecutors for far too long. And Judge Jackson and people like her, their experience as public defenders makes them a role model for the type of judge President Biden and Senate Democrats should continue to prioritize." So groups like Demand Justice have been very vocal in trying to steer President Biden toward appointing more people with this kind of background with an eye toward shaping policy, which is, I think, quite different. And sort of a strategic use of judicial appointments that we really haven't seen before. Now, on the other side of the aisle, ideologically, I guess, this is Carrie Severina, who's the president of the Judicial Crisis Network, which is a very conservative organization trying to call out what they call activist judges. And she says liberal groups are spending millions of dollars to help elect Joe Biden. They've become quite vocal in demanding judicial nominees who will help promote their liberal policy aims from the bench. And he has shown a willingness to do whatever he can to appease those groups. And she was talking specifically about the Biden administration appointing these record number of public defenders. Now, at the heart of these two competing visions is this assumption that people who have been public defenders will bring a different perspective to the courts, and that perspective will either further one's policy preferences or be antagonistic to one's policy preferences. And so we really wanted to understand whether these claims had any merit. One thing to note here, and this is just a plot of the number of public defenders for judges. I don't know if can you guys see my cursor? Yes, okay. So the number of public defenders is low, but thanks to these efforts by advocacy groups and then the Biden administration, they've actually increased quite a bit over the last 10 or 15 years. So we've gone from basically 0 public defenders, a handful in the 1950s, 1960s, I think this is like 1 or 2 appointments, to something closer to about 10%, short of 10% of appointments. That really does pale in comparison, speaking to the quote I had from Chris on the previous slide, Chris Kang on the previous slide, that does pale in comparison to the proportion of judges who have some sort of prosecutorial experience. So this right here, this kind of shows you kind of the imbalance that groups are both concerned with, but also this increase is kind of putting a special emphasis on trying to bring in more judges with this kind of experience. So we really wanted to know, okay, well, what, if any, difference will these judges actually make, right? So we want to get at the kind of empirical assumptions baked into this idea that they're going to make a difference. Like what's the difference that they're going to make? What does this tell us if we can extract any inferences about the relationship between a judge's professional background and their decision-making? And I'll come back to that at the end of the talk. And will this make a difference in terms of criminal justice policy? Is appointing judges on the basis of previous experience a useful strategy? Could it potentially make an impact not just in this arena, but in other arenas? Is this something that we can see political elites doing more of moving forward? So those were the key questions that were driving the project. Going into February, when Biden actually goes ahead and names a former public defender to replace Stephen Breyer. So we'd been working on it before Judge Jackson exploded into the news. All right, so thinking about why they could make a difference. So why do people like Chris King of Demand Justice think that it's really important to appoint public defenders onto the courts? Now, I think here work by people like John is really influential in terms of how we thought about this. So the modern literature on judicial politics that focuses on the impact of judicial background on decision-making and case outcomes. So this is work by John in his 2013 AJPS, and Christy Boyd, Andrew Martin, and Lee Epstein in their 2010 AJPS, points us to this idea that judicial backgrounds can be quite important in structuring or shaping or predicting decision-making, but they primarily do so when the case has some sort of salient component that's related to that aspect of identity. So in the Boyd et al. Paper, they're looking at gender in decision-making, and they find that gender is particularly important in predicting differences among judges, but it's primarily the case when the case has some sort of gendered component. And then I think in John's paper, it's pretty similar to that as well in the case of African-American judges. So if we took this literature and we thought about like how public defenders could potentially make a difference, it's probably going to be with regards to criminal sentencing, which is the kind of the strongest nexus and connection to what public defenders do on a day-to-day basis. Now, in thinking about which kind of direction we might expect to see the impact of public defense experience go, I think the connection that we saw as being the most salient is that we do think that the public defenders do have an empathetic connection with many of their clients. So public defenders are sort of asked to argue in favor of their client's interest. That kind of means that you have to step into the shoes of your client to try to figure out what would be the best for them in terms of sentencing outcomes, right? They're asked to argue in favor of their client's interests. And so because of that, we think that there's probably a strong argument that they sort of internalize the need for less punitive sentences. We actually, when we were thinking about this a little bit, and we had some preliminary results, we also sent them to a person we know who actually is a former colleague of Judge Jackson's on the US Sentencing Commission. And she actually, this argument kind of resonated with her, but she actually pointed out that the mechanism might actually be something slightly different. So she said, for public defenders, and this is quoting from her email, so we don't include this in the paper, but she says, she said to us, their proximity to real people and to clients means they always see the ways in which social structures affect criminal offending, and that they know that crimes are the product of those social factors, no jobs, poor educational opportunities, racism, et cetera, as well as individual choices. And so because of the public defender's kind of work in understanding structural forces, they might be less inclined to issue purely punitive sentences that sort of do not address kind of the broader, in this case, social structures that could potentially also be impacting criminality. I thought that was a really interesting point, and I've sort of held on to that as being kind of one of the explanations in my mind to explain the results. But we do think that kind of these experiences do translate into public defenders. The expectation would be that public defenders are going to be less inclined to simply punish for punishment's sake. And so that is kind of the way that we're thinking in terms of approaching the potential results. One flag in all of this is that there's this chicken and egg problem that we're not really addressing in this paper, which is that people that might have these inclinations might be more likely to become public defenders. And certainly, for example, in the case of Judge Jackson, she actually wrote her undergraduate senior thesis when she was a college student on criminal sentencing. And I think it was like the right to counsel or something. So it's clear that she already had an interest in these sorts of issues, even before she became a public defender. So that chicken and egg problem is something I'll revisit toward the end, because I want to be clear about what we can and cannot causally identify. Okay. All right. So let me just jump ahead and just start talking about the data and the results. Supreme Court justices don't hand down sentences. So as much as we'd like to focus the study looking at public defenders and Supreme Court behavior, that's not really a good context for us, not the least of which is the fact that there are no public defenders on the court right now until Judge Jackson is actually confirmed, right? So the Supreme Court's not a good context, but the federal district courts are. So it's The Supreme Court is at the top, and then we have the Court of Appeals in the middle. And then at the bottom tier of the federal judicial system, we have the federal district courts. And these are really federal trial courts. And so they handle trials, they handle the initial filing of civil complaints, but also criminal, they handle criminal trials. And that includes supervising and overseeing criminal cases that are both pled and those that advance to a trial. So we focus on sentences from the federal district courts. For data on the judges' backgrounds, we use data from the Federal Judicial Center's biographical database. For those of you who work a lot in judicial politics and in the space, this is like kind of a standard go-to data set on the backgrounds of federal judges. If you haven't worked on these topics, but you're interested in judicial politics, I recommend this data set. It's really clean, easy to use, updated. So they have demographic information on all Article 3 federal judges, I think going back to like 1789. I mean, I think it goes back pretty far. I think John would know. It includes age, gender, race, educational experience, like where they went to law school and undergrad. And then it has a brief blurb that describes their professional experience, kind of it lists sort of the professional experience of these individuals. So it's pretty comprehensive. It also includes political information. So the year of confirmation, the Senate vote, things like that. So what I did, I actually did this. So what we did was we scraped all mentions of the word defender in the professional experience section. And that basically was, and then I actually went back and actually like spot checked, but I was able to go through all of these, and that was basically to confirm that we were picking up essentially public defenders. So sometimes they would be called defenders, but sometimes they would be called public defenders. So we just scraped any mention of the word defender to identify people who had this kind of experience. And then kind of through the spot checking, I eliminated a few of them, like 3 people who were only volunteer or interned with a public defender's office. One thing that this does do, because we actually looked for people who had listed defender in their blurb, this does not include individuals who did do defense work, but did it, for example, in a law firm. So if an individual did defense work, but did it in a law firm, it would be listed as like associate Smith & Jones. Like it wouldn't say defense work Smith & Jones, right? So it's necessarily under-inclusive in that regard. So that's just one caveat. Okay, so this is an example of what an entry might look like. This is actually using the user interface. The raw data is a little bit more inclusive because it has race and gender and things like that. This does not. But this is Judge Jackson's entry. And you can see in her professional experience, she has that she was an assistant public defender. In the district court, she was actually an appellate public defender from 2005 to 2007. So that's pretty typical of what we'd find. I think it's more unusual to have an appellate public defender. I think most people were more like trial public defenders. Probably more of them were working in the federal courts, which is what you'd expect maybe for individuals who are eventually going to be going on to become federal judges. Okay. All right. So the data on sentencing outcomes was actually much harder to get. Data on judicial backgrounds is straightforward. The data on sentencing outcomes is quite a bit harder. So what we did for this project is we got special permission to pull data down from TRAC, the Transactional Records Access Clearinghouse, which is a data gathering, data research, and data distribution organization at Syracuse. TRAC is pretty interesting because what they do is they actually just keep filing FOIA requests in their areas of interest. So they're always pulling FOIA requests over and over and over and over again. They do it primarily for immigration, but they also do it for federal criminal issues. Right, so this is just from their webpage. They continuously use the law to obtain new data about government enforcement and regulatory activities. In some circumstances, TRAC has filed suit in federal court to force the release of vital data critical to TRAC's use. A FOIA is a small army of lawyers who donate their time and energy to represent us in court. For purposes of this project, all federal criminal enforcement activities are covered under any law or Justice Department program category by any agency and in any one of the 90 federal judicial districts or for the nation as a whole. So it's pretty comprehensive. I think the catch with using these data, if anybody's interested, I'm happy to talk about it, is that you don't really get a sense aside from the sort of their self-described auspices, you're never really sure that they have captured the universe of data. That's one thing. But the other thing which I have here is that it's basically raw FOIA data that's been digitized and then minimally processed. So there are actually variables in the data that you have no idea what they are. And there was one variable I just couldn't figure out what it was, even after a lot of work trying to reverse engineer it. And I actually emailed the person at Track and I was like, look, I don't know if you know what this variable is. And she said, I do not, but if you find out, let us know. So that was like my experience working with this data, was that it's voluminous. There's a lot of it, but it's quite messy because it's not really clear where some of it comes from or like how it's coded. So that's sort of a caveat about the Track data. Okay, before I show you actually some of the raw data and what it looks like and what we're working with, just some context about federal sentencing. So one thing that's true in this is that most cases are pled, which means that defense and prosecution come to some sort of agreement. It's unclear to me how much the defendant is an active participant in that plea. But when a case is pled, the judge can still depart in terms of the actual sentencing at the end from that plea agreement. But it's probably the case that they're going to use more restraint when there's a plea than when the case goes to trial. And so there's a distinction often in this literature between cases that are pled and cases that are going to trial that I think we need to be mindful of when looking at this question. The other thing that we need to be mindful of in terms of thinking about how to study these questions is that many cases actually in the federal system that are not serious, that are not felonies, that are eligible for elevated punishment, they go to these individuals called magistrate judges who are non-Article 3. That means they don't need to be confirmed by the Senate. And there's no FJC data for them. So it's sort of like kind of a different process. These magistrate judges are authorized by statute to handle these cases kind of specifically, especially. But it does mean that because we don't have data on them, it's very hard to kind of link these up with public defender experience. It's not really possible unless you went and collected data on the magistrate judges. So what we ended up doing in the analyses is dropping the cases that went to magistrate judges and then trying to deal as much as we could with pleas and trials separately because of the kind of the way that these would be kind of evaluated differently by different judges. The latter, the pleas and trials, like whether a defendant goes on to enter into a plea agreement or whether a defendant wants to go to trial, that could be affected by the identity of the judge. So we have some analysis in the appendix looking at that, and I can show you those slides if people are interested. All right, so just what these data look like. First, we looked at essentially instances where there was a sentence where the defendant had a guilty disposition, was guilty basically. I don't know why they call it guilty disposition, but the defendant was guilty. So right here we had in our data, and this is from 2010 to 2020. So we had about 725,000 individual charges where the defendant had a guilty disposition, where there was a guilty disposition here. Of those, the lion's share are pleas. And then some subset actually went to trial. Right, so 84% of these were pleas. Also, just to give you some sense of what the punishments were that were associated with these, there are three different kinds of punishments. There's a fourth one, which are fines, but almost everyone is fined, so we didn't really focus on that. But the three were incarceration, community service, and probation. So those were the three sort of key outcomes that we focused on. And a charge could have a sentence that involved incarceration and community service or incarceration and probation. So there could be combinations of these and also fines. And you can see that 80% of the guilties that were pleas resulted in incarceration, 88% of the trials that were pleas resulted in incarceration. So conditional on sort of being guilty, a lot of these are headed to incarceration. Like whether they're actually incarcerated or not is sort of like later, but there was a sentence of incarceration. And we also have information of how many months that incarceration was. Actually, also the number of hours of community service and months of probation. So we had information on not just whether there was any of these outcomes, but sort of the duration of these. All right, so talking about the research design, and I see some comments in the chat. I don't know if I should look at them or keep going.
No. Everything's
Keep going.
fine.
Okay. All right.
One
So in
question I
terms
had
of
very quickly is going back, because the pleas and the trials don't add up to the number on the right? The all guilty disposition?
no,
Okay.
because you could have. So that's one thing that made working with these data. We had to do a lot of choices about how to subset, but there were instances where people would plead but not admit guilt, essentially.
Okay.
So it's like none of these columns actually add up to each other because there were different categories where people could be opted out of different subsets of the data depending on what kind of plea they struck. So yeah, at each stage, very little adds up.
Got it.
Yeah. There were a lot of choices. Yeah, it's true. There were a lot of choices in how we subset the data. Okay, so here's bird's eye view of some of those steps that some of those choices we made. So we narrowed the sentences down from the entire universe to just looking at sentences between 2010 and 2020, like sort of a good expansive number of years. Also, if you guys recall that plot with a number of public defenders, this is sort of captures the moment in time when we have the most public defenders in the courts, right? In terms of causality and thinking about causal identification, what could we claim to identify with these data? So what we're really looking at is the charge and then the outcome of that charge, whether there was a guilty disposition and then what like the sentencing involved. So what we're looking at really is the effect of a case being assigned to a former public defender versus not. Right. So that's sort of the way we're thinking about the identification. And we can sort of claim a plausible causal design on that, because once we've actually included fixed effects for district, year, and month, we would expect that cases, right, would look roughly similar across those that are assigned to a former public defender versus those that are assigned to not a former public defender. So we didn't really have much covariance on the unit side, which is the case. But given that we have the fixed effects for district and year and month, we can sort of claim that the cases are randomly assigned to judges, regardless of their previous professional experience, right? Because cases are basically quasi-randomly assigned to federal district court judges once they come in. So, right. So once we have the district, year, and month, we can sort of claim that random assignment. We do have basic covariates on sort of the treatment side. The treatment is the judge that the charge is assigned to. So we have fixed effects for the identity of the appointing president. Later, I'll show you some results where we look at differences among party. We have race, age, which we proxy using confirmation date, and gender. So we have sort of basic covariates on the treatment side. We also cluster the standard errors on case because there are multiple charges coming from a single case. And then we cluster the standard errors on defendant because it's possible that one defendant could come up multiple times across the 10 years of our data. Although I have reason to think that the defendant IDs are I don't really trust that variable very much. So.
What's the thought on the month fixed effect? What is it about month?
I don't know. So it would be something like you see different crimes, across different parts of the month. So that would be one reason why you'd include different fixed effects per month. But primarily it's because when a case comes in, it would be randomly assigned to the available judges sort of on that date. And by including month, you're sort of getting at that conditional on month, you would expect that the assignment of a case to a judge would be, as close to random as you can get.
Okay.
I think because we have so many observations, it's possible we could include, week or something. I'm not sure we could include date, like actual day, but it's possible we could even include week, to be honest. But that's what we're trying to get at, is sort of like as close as possible as we can to being able to claim kind of a random assignment. Yeah. So in terms of the outcomes we looked at, we were actually interested in severity. So the most severe type of punishment was incarceration. So we looked at incarceration or not. And then we looked at incarceration length. And then, as you'll see, we looked at incarceration, like extremely long incarceration sentences. So for ease of interpretation, I'm going to show you a bunch of results essentially using a linear probability model for binary outcomes, incarceration or not, or ordinary least squares for continuous outcomes such as sentence length.
One more question here, Maya, before
Yeah.
going on. From the audience, Allison Holt, one of my graduate students here. Are you looking at length of time the person served as a public defender? Might be able to tease out some information on how much is intrinsic motivation versus attitudes gained on the job.
No, that's a great suggestion. We might be able to extract that data, Allison. Right now, we're just looking at public defender experience, yes or no, but we might be able to extract years served. Yeah, it's a good suggestion. I think it would just require a bit of parsing of the data to try to extract that information in a reliable way. And try to, I think it would also require us thinking about what it would mean to compare a judge who's not a public defender to a judge who only had 1 year public defender experience or 2, you know what I mean? Like how we would think about that comparison. But that information is generally included in the FJC data, so we'll think about it for sure.
Excellent.
Yeah. Okay, so let me start showing you some results. I'm not sure how I'm doing on time here. Okay. All right. So for the first result I want to show you is just whether a charge led to incarceration or not. And so I've split it up into trials right here. So these are cases where it proceeded to some sort of trial, either a jury trial or a bench trial. Then cases that were pled. So these are cases where the defense and the prosecution came to some sort of agreement, and we think that judges tend to exercise less discretion over these, and then all of them combined. So this is the linear probability model. So this is the sort of the public defender effect. So this would be suggesting that being assigned to a former public defender would be on the order of about 2 percentage points less likely in a jury or bench trial to result in incarceration. Kind of a substantively similar size effect for the cases that were pled. So close to 2% percentage point effect, and then sort of a 2 percentage point effect across all cases. And then, we just have the kitchen sink of covariates on the, mostly on the treatment side. Although here we do have all those fixed effects for district, month, and year. And then we have a control for whether the charge is labeled. This is kind of showing you how the sausage is made, but showing you that the charge is labeled with an F as opposed to, I think it was an M for a misdemeanor. We think that's the charge as a felony, so we included that as a control. Actually makes sense. I'm pretty sure that that's what it is. But that's what we had to deal with working with this data, is trying to make the best guesses we could as to what variables meant. Right, so this is not a huge effect, but it's not nothing either considering the volume of sentences that we're talking about. So it's also fairly robust to different specifications, different subsets of the data. Couple of other interesting points here. You'll note that we also included a control for whether the judge had that former prosecutorial experience. And you can see some significance here on pleas. And then when we group all of the sentences together, this is not surprising given that we have sort of an effect here. So about 4 percentage points. You can hold on to that because then when we look at incarceration length, we see some different patterns. So this is sort of like once you've been sentenced to incarceration, the data also included in months the length of that incarceration. So again, we have jury or bench trials here, charges that were pled, and then everything combined. Now this was strange to us. Right, so there's a huge effect for a charge being assigned to a case being assigned to a public defender for trials. So this is an 18-month difference. That's significant, the 5% level, and no such difference when charges were pled, and then because pled charges are 80% of all of these cases, you get sort of a mixed effect here that's borderline significant for all cases. Right, so this to us was weird. When you include everything else, there's some weirdness, obviously, with this kind of stuff here. But this is also interesting that there's sort of no significant effect for prosecutors in this column. You do see it here, about 1.5 months here. But this is the one that jumped out at us. Again, including all of the, sorry, I keep highlighting stuff on the screen, including all of the fixed effects down here. So this was a big effect that kind of weirded us out. So we started looking at the data more closely to try to figure out what could potentially be leading to such large differences. And it turns out, unpacking this kind of led us to kind of maybe reasons why, but it turns out that there's a small number of people who are sentenced to very, very, very long sentences. In fact, I think we discussed this in the paper. I'm not sure the exact number, but there are people in the data who were sentenced to like 500 years in prison, 300 years in prison, over 100 years in prison. And it turns out that public defenders are less likely to sentence people to those very, very long sentences. So we actually plotted that out to try to get a sense of like this particular pattern. So this is a plot where we have all of the incarcerations that we had in months, just disaggregated by all judges. And then this is former prosecutors. And then this blue line are the former public defenders. We actually truncated this at 100 years. So anything above 100 years was just counted as 100 years, which is effectively like a very severe life sentence. And you can see like this blip over here, you can see that public defenders are going to be less likely to sentence individuals at these very, very extreme sentence lengths. So this is what sort of we're picking up. And given that we're truncating this data actually extend out quite a bit to like 500 years or whatever, this kind of trend continues. If we were to show you a plot that kept going, right, this would continue. So it seems like this is something that's explaining that 18-month difference. So what we did was we actually looked at these extremely long incarcerations. Among criminal defenders, 30 years, anything over 30 years is essentially treated as a life sentence. So we looked at that specifically. So this is a linear probability model, just including an indicator for whether the sentence is more than 100 years, or whether it's more than 70 years, or whether it's more than 30 years. So across these different measures of what you consider to be an extremely long sentence, and again, public defenders sort of, or people in the criminal sentencing space kind of look at anything more than 30 years as a life sentence. Public defenders are less likely to give out those sentences. Now, this is for verdicts only. So this is in those spaces and in those cases where we think that judges exercise more discretion. And you don't actually see that for prosecutors, right? You don't see that at all. These are some non-precisely estimated zeros. So this to us was sort of a compelling narrative. We actually took this back to the colleague who works in the space, who was on the Sentencing Commission with Judge Jackson. And this particular finding really resonated with her and really kind of spoke to her, because her sense was that what public defenders want to do is they want to avoid punishing people just for the sake of punishing them. And something like this, a sentence that's more than 100 years, more than 70 years, even more than 30 years, is sort of punishing people for the sake of punishing them. And so yes.
And why is the number of observations the same on each of those?
These are just guilty verdicts. So this would be any sentence with the same subset of data, just truncated at different points. Right. So this would be if the sentence was more than 100 years, if the sentence was more than 30 years, if the sentence was more than 70 years, and if the sentence was more than 30 years. That's the same subset of data.
Do you have a sense of how many cases that actually came down to in those three?
Like more than 30 years?
Yeah.
I think it was a couple of thousand.
Okay. And that's murder. And
yeah, when you're talking about something like that, it would have to be some sort of aggravated charge. So it would have to be like murder, but involving like a law enforcement officer or something like that. It would have to be some sort of aggravated or compounded sentence. We do have some information on the nature of the charge, but it's inconsistently coded across the different observations. So I think it would not be possible to try to include some sort of control for that. We talked about it, and I think it would require manual coding of some of this data. And with the number of observations, I don't think it's possible. Let me just quickly show you some other kind of interesting pieces of information that add more context to the story. So Allison in particular was interested about, well, if they're not sentencing people to these very long sentences and they're less likely to sentence, are they doing something else? And so the less punitive sentences that could be given out were community service, and then followed by some combination of community service and probation. And so we looked at that as outcomes specifically. Now, these are charges in which incarceration was not on the table, or incarceration was not handed down, right? So and these are small effects, but it's true that public defenders are more likely to sentence individuals to community service only, although that's like a very small, I mean, we're not hanging our hats on this. This is very small. You could say it's precisely estimated 0, basically. Some combination of community service or probation, which would be the next severe kind of tier of punishments, and then community service and probation. And then you have the full suite of controls. And then the last thing I want to show you before kind of wrapping up is people were really interested in trying to figure out whether there was some sort of interaction with party. And all of the results that I've shown you so far include fixed effects for president, right? So we're comparing Trump judges to Trump judges and taking the average effect across these different comparisons. But people wanted to know like whether the effect would be more or less strong among Republicans versus Democrats. And so we included a few interactive models. The caveat here, I think, is that there are quite few Republican appointments that have public defender experience. So I would not make a huge deal out of these, but you can see at the bottom here where we do interact public defender experience with the judge being appointed by a Republican. This no longer has presidential fixed effects. When we do that, there is some, I would say at most this is suggestive because it's not consistent, at most suggestive evidence, I guess, that the effect is sort of stronger for public defender Republicans than Democrats. But again, these were not super robust across different specifications, and you can see that there are times when it's not significant. So I wouldn't make a huge deal about this potential difference, especially when you think about the fact that the lion's share of people with public defender experience are Democratic appointments. I wouldn't make a ton of hay over this one. Okay, so just to wrap up, just to think and pull back and think about the substantive implications here, we set out to try to investigate how much of a difference packing the courts with public defenders would make. We did a back of the envelope calculation to try to back out kind of a figure on that. So if we increased, if President Biden was able to increase the percent of judges who are former public defenders to equal the percent who are former prosecutors, which is about 30 or 40%, we'd have around 13,000 fewer federal incarcerations in a 10-year period. Now, given that we have millions of federal incarcerations in that same, or I should say, millions of charges in that 10-year period, I think that's not huge. And I think it's important for us to acknowledge that it's not like a huge effect, but it's also not nothing, right? These are individuals who are potentially going to be incarcerated versus not. And these are real people's lives and real implications associated with that kind of incarceration. Now, in a much smaller share of cases that proceed to trial, former public defenders do appear to reduce the initial incarceration sentence by a lot. And that appears to come out of the fact that they're more hesitant to hand out extremely, extremely long sentences that are primarily punitive. Now, again, the caveat with that is that these are even smaller numbers. There are even fewer cases that proceed to trial. So even this will not signal a huge policy shift. But again, it's not nothing. So our take, and this is me speaking for Allison here, is that judges who are public defenders can indeed sort of change things and advance policy, but it's a pretty late stage, and it's not going to be a substitution for a broader policy approach. Now, in terms of where our research contributes and open questions, I think we contribute to growing work showing discrepancies faced by criminal defendants in terms of the criminal justice system. I think we do contribute to a growing literature on judicial decision-making and its relationship to judicial backgrounds. I think the caveat here is that we do not identify the effect of public defender experience on the judges themselves. And the reason why is because people can sort into different career paths based on their proclivities and their personal interest. If I had to guess, I think it's column A and column B. It's both the experience and the selection going into that experience. What we do identify is the effective case assignment to former public defenders. Right, and that leaves open the interesting question of how to identify kind of the former, which is how you identify the effect of background on decision making. The big picture, though, I think, is that this is a trend that's going to continue. So policymakers are going to increasingly try to shape policy in these directions by trying to specifically select people on the basis of their professional experience. And this example of Democrats using public defenders, I think, will be followed closely by Republicans and Democrats. And you could easily see how this kind of strategy would be employed on the right. So I will conclude there and hear comments from John and take notes.
All right. Thank you, Maya. And as I said at the beginning, we have a formal discussion, and it's John Kestel from Princeton University.
All right. Thanks very much. Thanks to Jeff for inviting. So somehow Jeff had the foresight to schedule this the week of the first public defender on the court in 60 years before she was even nominated. So well done. I wish I could claim, that I had some foresight. I did. Great. So just to summarize what I'll try to do in my talk. So just the broad picture, the most important points are really a great paper. It's really interesting. It's important, timely question. Hugely impressive data collection and careful analysis, right? So those of us who work in appellate courts, on the one hand, have the luxury of just kind of being able to work with published opinions, and we can code things as, liberal or conservative, but that's quite limiting. And so here we're actually dealing with the outputs of courts that directly affect, hundreds of thousands of litigants each year. So I think it's a great project. I'm looking forward to see where it goes. So my comments will fall in two buckets. I guess I'll have some smaller suggestions on the data and analyses. And then I'll end with some theoretical thoughts on strategic plea bargaining and how that has some possible effects on what we observe from sentencing. Maya discussed this a bit. So there are different types of outcomes that can happen in the judicial process, right? You could plea, the prosecutor can drop the charges, there could be a trial, there could be acquittal and guilty verdict and so forth. So this is one of the things in practice, it probably doesn't matter, but they give me a little pause to condition on outcomes, right? So outcomes are definitely downstream of the assignment of the judge to a case. And so even though there are very few acquittals, which is the main thing we'd worry about, just maybe some foreshadowing of how the choice to kind of subset on different outcomes might be beneficial. The appendix looks at this a bit, but it's not discussed much in the papers. And here, perhaps more consequentially, so as we saw, some of the models pool bench and jury trials. So in a bench trial, that means the judge is the arbiter of guilt or innocence. And so they have full discretion over whether they get to sentence the defendant or not, because if they find the defendant not guilty, then obviously there's no sentence. Whereas in a jury trial, they're overseeing the process, but they're not, in most cases, directly influencing the outcome. So I guess I wasn't sure about the implicit theory about what judges, their influence in jury trials, right? So we'd expect them to, say, set up the proceedings or rule in favor of the defense more often. And if so, that might have implications for how we think about pooling these two types of trials together. So as Maya mentioned, so one weakness of the track data, as impressive as it is that we don't have any case facts or the exact charge. And as Maya mentioned, I guess even the data on whether it's a felony or not is questionable. So I guess that's a little worrisome. And as you were presenting, I was thinking, shouldn't a felony induce a lot more than it was basically 9 months on average was the difference? Yeah. So a felony is usually, right, you get at least a year. So it seems like it should be more, but I'm not sure about that. So one thought, that it's not a pleasant thought, it'll be a lot of work, but the FGC data on cases has a bunch of case facts that are filed by the courts. It doesn't have, one reason we don't use it because they decide to hide the judicial identities for fear of bias or impartiality or for some reason. But I don't know if track data has docket numbers, but if so, no. Okay, that was the thought, that you can merge it. So why would you do that? So the small benefit was that you could show random assignment more convincingly. I'm one of the people that you don't have to convince that the assignment is quasi-random, but a lot of times when people read the claim that you get random assignment at either the district courts or the Court of Appeals, people, especially economists, don't believe it. But the bigger thing you could do with it, I think, is you could leverage where we expect the differences in incarceration or sentencing to kick in. And I think Jeff was getting at this with his last question, because where do we think about, where's the marginal impact of having experience going to matter? It's going to be on the marginal case, right? So any judge would sentence somebody convicted of murder to X number of years in jail, right? So we're thinking here about the binary incarceration decision, right? There's no real discretion absent some kind of extreme circumstances. But on the smaller felony or even a misdemeanor, right, that's where the marginal case would be in. And so if we could focus more on those case facts, maybe we could get kind of more finely tuned estimates of the impact of experience. I don't think it's a bias issue per se, but it might, again, focus our attention on the area of the data where these effects are most likely. And similarly, we think about sentence length. The differences in sentence length are likely to kick in only above some threshold, right, that we can statistically detect, right? So take a garden variety robbery case or theft or something where the sentencing guidelines call for 3 to 6 months, right? Probably, given the noise in the data, it's going to be hard to detect any difference in sentencing. Whereas again, if we go up the scale where there's going to be a wider range in the sentencing guidelines, so murder, kidnapping, stuff like that, right? Then again, there's more kind of pull in the string that we could actually see based on experience. But if you can't get it, you can't get it. So okay, so I guess I was broadly convinced by the two main analyses. I was a little less convinced by the severe sentence length analysis. So this density plot that Maya showed kind of motivates this. And so a couple issues here. So one, right, we see a bump here where prosecutors kind of sentence more in this range, but it's hard to say, right? There are a couple of reasons we could say that, right? Because you could, right, public defenders could be sentencing more on this side or kind of spreading out their decisions more across the range. And also this density plot goes below 0. So it's hard to know, why exactly we're seeing that. That's a smaller thing, but I guess the main thing is that these cut points of, looking at 170 or 30 years seem fairly arbitrary. And any cut points would probably seem arbitrary. So one idea I had is that instead of picking years, kind of exposed to that visual display, just let the cut points roll across the range and then run 100 regressions and then kind of plot the coefficients. And if the coefficients on public defenders are fairly constant across the thresholds, it suggests that you're just capturing some baseline propensity to have lighter sentences, which kind of, filters through no matter where you are in the range. Whereas if the coefficients become absolutely larger, so the effect on PD becomes bigger, I think it's more supportive of the severe sentence hypothesis because we're seeing it kind of kick in as the threshold goes up. Just one idea there. Okay, so let me switch to the bigger issue here, which is thinking about the role of plea bargaining. And so we know that most criminal cases these days result in plea bargaining, so upwards, I think, of 90% in the federal system. And of course, plea bargaining is done in the shadow of the expected sentence that you would receive if you chose not to plea and the case went to trial. And so imagine that parties are aware that former defendants sentence lighter than other types of judges, right? This should affect bargaining and thus observed outcomes, just like any other factor about the trial would. And so here's a really simple model that kind of sketches out how this works. So imagine there's a game where, right, treating the charge as exogenous, right, or the arrest. The prosecutor makes a sentencing officer, which will be in some range. We'll call that SP, and the defendant, they can accept that offer and they get SP for sure, or negative SP, where the prosecutor gets SP. So imagine the prosecutor gets utility in the length of the sentence, and the defendant gets negative utility in that same length. So the defendant can accept that with certainty, or he can reject it and go to trial, where the outcome of the trial will be conducted by nature with some probability B. And if they're guilty, you'll get some sentence ST, which usually would be higher due to the trial tax, right? You generally get a higher sentence if you go to trial, minus the cost to the prosecutor of conducting the trial. And the defendant would get negative ST. And basically they do the best if they get found not guilty, where that's worse for the prosecutor. Okay, so the actual model here is not so important, but right, if we believe the story, right, having a judge who is a public defender should decrease ST. And in this story, right, in this setup, it's deterministic, but you can imagine there's some probability that, right, if you have a former defender who's a judge, he or she's going to sentence more lightly on average. But it also may decrease P, right, the probability of a guilty verdict, if the mechanism travels to at the verdict stage, right? And that depends how we think about what's going on at trial, going back to my earlier comments. All right, so hypothetically, suppose judges were not assigned to a case until after the plea bargaining phase. So plea bargaining is more fluid, but imagine right at the moment the trial begins, right, that's when you learn who the judge is. So there, we wouldn't expect much strategic settlement conditional on the judge, although the prosecutor and defender could still condition on the probability of drawing a particular judge or not. But this implies that judges with defense background should be less likely to incarcerate and also issue shorter sentences conditional on incarceration. And I think, and Maya can correct me if I'm wrong, that this is kind of the world the authors are implicitly assuming. Right, so basically, there's not much strategic settlement going on. Now suppose, and so I don't know how this actually works. So I asked a former student who's a law professor. He reached out to some people who work on federal trials. And I think in reality, the plea bargaining phase occurs after judges are assigned, right? So I think the way it works is that a defendant gets arraigned, in which case, he would then be assigned a defense attorney for most people with public defenders. And then the judge is assigned. Then some trial date would be set, months or years down the road. And then the bargaining phase starts. So if that's the case, right, we should see some form of strategic settlement or conditioning on the outcome of the judge, which means that the assignment of the former defender, ceteris paribus, should either cause the prosecutor to offer a less severe plea deal, right, because they know that the expected probability at trial is better for the defendant, and or increase the desirability for the defendant of going to trial, right? And if this is the case, both of these factors would have implications for the types of cases that former defendants are issuing sentences, right? So the distribution of case types would differ across defenders and former public defenders and not, which kind of affects the random assignment assumption. And under 2, it seems plausible that former defenders should sentence more harshly, right, kind of counterintuitively, conditional on the guilty verdict, because they're getting case facts that are more extreme, right? Kind of similar to a taste-based discrimination story, where you're observing different outcomes based on the screening process that goes on. And so there is some discussion in the appendix, and it was kind of cursory, but I think the authors noted that this means that the true one implication could be that the true effect of the public defender could be much larger than the naive estimates suggest, right? So if this is true, we want to flesh out the theory a bit more than I did there, but it could be that the actual effect is much larger, right, if you control for the strategic settlements going on. But either way, I think it's worth fleshing out these mechanisms in more detail. And it can be done in tandem with the earlier comments about different dispositions and case facts and how they affect kind of what we observe from outcomes. And then one further thought that's also not pleasant from a data collection perspective is that I'm wondering if there's variation across districts in when judges are assigned to cases, right? So it might be, so on some circuits, there's variation in when the panels are announced. I know and people looked at that. So I'm wondering perhaps in some circuits, the judges are assigned more earlier or later, which would give you some nice variation and some exogenous variation that could test these mechanisms. So I just had a couple, as you were talking, I had a couple other thoughts, which is, I guess, advantage of a virtual presentation. Do I have 3 minutes, Jeff, or should I wrap up?
You have as many as you like.
Okay. So one way, this actually came up in Jackson's confirmation hearings, right? So you're just trying to treating each month as a month. But the way the guidelines work now, I think, is that there's a recommended range set by the Sentencing Commission. It used to be the case that it was hard for judges to deviate because they were mandatory and now they're advisory. But there's still this issue of when judges should go up or down below the guideline mins or max. So I'm wondering if you could treat deviations as a DV, because that would kind of get at the choice to actually go beyond what the easy thing to do is. And that might speak more to kind of, internalized views about the sentencing process. On your kind of intro point about this distinction between policy and background, I think it's certainly worth thinking about what's going on with the Democrats' focus on public defenders. But I'm wondering how distinct they really are, right? So if you think about Supreme Court nominees these days, almost all of them are former or on the Court of Appeals, right? They all have very highly professional background. They're generally Ivy League scholars. A lot of them worked in the executive branch. And so we might think about those as good things in their own right from the perspective of the appointer. but also they're very highly reliable signals of the type of judge that you're going to be, right? So here we can think of a Democrat wants liberals, especially now, given how polarized the courts are. And so the fact that you're a former defender is probably a good signal, given uncertainty about the mapping between experience and outcomes, that you can use to rely on. I mean, it's also the case that interest groups are pushing for this, so you're kind of killing two birds with one stone. But I don't know necessarily that they're distinct. And then the last thought, going back to my bias about thinking about appellate courts, I wonder if there are enough former public defenders on appellate courts now that you could actually see if they affect both basic appeals, sentencing appeals, but also sentencing policy. So for one, I know there were papers that kind of looked at the rollout of the sentencing guidelines and how different judges ruled. So that was in the 80s, I think, but maybe there are enough former public defenders as appellate court judges that you could actually kind of travel your story to the appellate courts. That's it. Hope those are helpful. I look forward to seeing where the project goes.
Okay. Maya, did you want to comment on anything John brought up?
Yeah, so thank you so much. That was super, super useful, because we had thought a lot about the way in which guilty dispositions could vary across public defender versus not public defender status. So in your decision tree, I think you had nature node as being the guilty versus not. And the way I was thinking about it was that public defender status could actually shape that decision node. Yeah, that one. So you had nature being the trial. Like I actually, right? I mean, I thought a lot about whether the kinds of guilties were different across the two groups, which is how we wrote it in the appendix. But we had given less comparative thought about the way that it could impact the plea agreement itself. I think in part because we have, probably this is me not speaking for Allison, there's a lot of literature kind of suggesting kind of the power of the prosecutor and sort of compared to the defense attorney, and sort of I had not kind of thought about the judge being kind of the two players, I guess, defense attorneys and prosecutors operating in the shadow of the potential judge. I had not given that thought. So that was really helpful. Yeah, so these are all good suggestions. There's some stuff that we can't do, John. So we can't do a lot of stuff with case background covariates unless we find a way to link it up with some other data set. And from a recollection of what the data look like, I don't think they include docket numbers. So there's some stuff that we are sort of limited, but it's possible that maybe we could take a subset of FJC data and try to figure out the judge involved, and then try to do that kind of as a proof of concept for some of these issues that you raised. So that's helpful.
Do they have dates on them? And must have.
Yeah, they do. They have dates on them.
So if you have dates and districts, then maybe, yeah, it's really annoying they scrub the judges, or else it would be easy.
Yeah, or else it would be easy.
Yes. Sorry, just one clarification on the game. Yeah, so you could flip nature. You could just make the district court judge the actor here.
Yep.
With some probabilistic distribution that they decide guilty or not guilty. So,
yeah, and the way that we were thinking about it was that let's see how it would work. So it would be the case that the public defender would be more lenient kind of at the guilt assessing stage, and therefore the cases that advance to sentencing would actually be sort of more severe. And if anything, that would mean that public defenders would probably be more harsh if it was a gatekeeping issue. That's sort of the way I was thinking about it. But I was not thinking kind of one step before that, which is the plea, not plea. And there was a question in the chat, actually, that went to me about whether I could say anything about the descriptive characteristics of people who are public defenders. Yeah. So in terms of the people on the courts who have public defender experience, I don't have this broken down either in the talk or in the paper, but just based on what I've seen in the data. So it overwhelmingly tends to be that a judge who's a public defender on the courts is much more likely to be a Democratic appointment. I believe women and people of color are overrepresented in that group as well. So the two things sort of go hand in hand, because Democrats also tend to appoint more women and people of color. And so they're appointing people with a more diverse kind of portfolio of experiences. And so all of those things go hand in hand.
Yeah. So I was just wondering when I asked that. So was over time, as you see more public defenders become federal judges, is it because of their public defender background, or is it because Democrats are trying to better represent groups in society and they're just looking for the underlying distribution that will allow them to do it? And that brings in this group that had been largely ignored before.
So I think right now, absolutely, the answer is the latter. So right now, Democratic strategists are thinking about what they want the courts to look like. They realize that this is a group that's been underrepresented. It's an appealing argument to make to the public that if you have this many prosecutors, the flip side of the coin is to have public defenders as well. And that's the argument they're making. And they're going out and actively looking for people who have this kind of experience to promote to Joe Biden and other Democratic policymakers and senators and things like that. I think over time, as this is sort of purely kind of what I've come to understand about judicial appointments. I think over time, the more people realize that being a public defender could be a path to a federal judgeship, then that will attract candidates who are interested in signaling that interest. And that historically has been the path that people who go into U.S. attorneys' offices and serve as assistant U.S. attorneys, so prosecutors, have tended to follow. So one reason we might not see sort of as consistent effects for prosecutors as we do for public defenders might be because people who work as prosecutors tend to do so primarily as a signal of their interest in a judicial appointment. And that doesn't appear to be the case quite yet. And this is anecdotal. This is just sort of me talking. That I don't think that's the case for public defenders just yet, but maybe that'll change.
It'd be fun and something you do pretty quickly. You should do some interactions, public defender with some of the demographics that I mentioned here, and just see if there are any differences within type.
We've done those interactions with gender and race.
Okay.
And none of those come out as particularly interesting. The one that we were kind of theoretically motivated by the literature to look at is the interaction between public defender status and a judge being Black. So there's some work, John, I think your work speaks to this, but like there's some work in the criminal justice context that shows, although the findings are not consistent, that Black judges tend to be more pro-defendant, particularly if the defendant is Black, right? So I thought there might be an interesting interaction there. And I believe this is in the appendix of the paper. I believe there was there's no significant interaction there. And there's no significant interaction on gender either.
Okay.
Yeah, so that stuff is in the appendix. Yeah, I don't know if there's other interesting possible interactions to look at. But those are the ones that I did look at.
I'm just wondering a little bit more about the dependent variable. How much information you actually have. You said it's kind of, the data is kind of not great, right? But do you have anything about the characteristics of the who is,
like the defendant?
Yeah, nothing at all.
No, the only thing we have is a unique identifier. And I even think that identifier is not consistently coded.
Okay.
So ideally, you'd have a defendant that they have the same identifier that's used across different charges. And I just don't even know if I can trust that, to be honest.
Okay.
Yeah. But this isn't the kind of data set where there's any information on the defendant.
So potentially you could have a race effect buried right within here, such that public defenders who are Black react to individuals who alleged to have committed a crime, right? That share their background differently than.
There could even be a public defender kind of interaction along the line suggested by our colleague who served on the Sentencing Commission, where she pointed out that public defenders are really sensitive to structural forces. So there could be interactions with sort of like the background of the defendant in terms of like age, economic status, and things like that we wouldn't be able to pick up. But I think to be honest, I think that's one thing that makes this, I think the first of hopefully other papers investigating this question and these sorts of effects, because I think these are open questions. And also this idea of what effect are we identifying? We're not really identifying an effect, but on the kind of experience side, what is it about the experience that matters? Is it experience versus selection? I think those are really big open questions.
On the whole, though, I wouldn't expect this effect to be very big, right? I mean, you would expect the effect, if it exists, to be small. potentially you don't, if you're deviating significantly from what other federal judges are giving out, that could create a problem for you, right? I mean, raise the attention of interest groups, members of Congress, that sort of thing. So I could imagine that there would be a significant difference, but it would have to be pretty small.
Yeah. And one thing also that, I don't know, John, if you know any work on this, one thing that we asked people who work in the space is like, well, are there papers showing when there is judicial discretion versus when there's not? Like, are there instances, for example, in pleas versus verdicts? Like, you might think there's more discretion exercised in verdicts as opposed to pleas. And she actually said there's not really any empirical work on that stuff, which is interesting. And by the way, there's apparently a strike happening outside my windows. I don't know if you can hear that, but I'm not sure what they're protesting this time. But anyway, I think there's just like there's definitely more research to be done on these sorts of questions, and those speak to some of the issues that John raised in his discussing comments.
It's always good to be the first one in, right?
Yeah,
for sure. So I don't know that I have any other questions. John, do you have any follow-ups or anything?
No, I don't think so. I guess I'm not aware of that question, but I mean, it has to be the case that you exercise more discretion for guilty verdicts than pleas, right?
I think so.
Something has to go wrong to disrupt the plea, right? So I can't think offhand of anybody who's looked at that.
Okay, so we'll let Maya go join the protest.
It's an anti-apartheid protest.
Okay. So want to thank both you and John for spending some time with us today. And I think it's a really interesting paper. And I think you're probably right that it will be the ship that, leads a bunch of other ships into the harbor over time, right? I think that's a good way to end things, I suppose, in that odd metaphor of mine. So again, thanks, Maya, very much for sharing your paper with us today, and John for providing comments. And thanks to everybody out there at home who joined us. Ann Johnson from the Bedrosian Center, who helps me all the time with all kinds of things. And we're going to be signing off here today from the Pipe Workshop. Have a good rest of your Tuesday afternoon.